Today's topic is United Nations Agencies for Protection of Rights to Indigenous People. Introduction. The UN agencies or organs plays a significant role in strengthening the UN system as well as in implementing the mandate of the UN. The initiative of the UN agencies for indigenous people could be traced back to the UN Commission for Human Rights, now Human Rights Council since 2006, particularly the UN Subcommission on Prevention of Discrimination and Protection of Minorities. Now we call it Subcommission on Promotion and Protection of Human Rights, and the International Labour Organization, UN Special Agency. The establishment of the Working Group on Indigenous People in the year 1982 by the Subcommission on the Promotion and Protection of Human Rights has strengthened the movement under the UN system. UN agencies or organs. UN has 6 core agencies or organs. They are the source of strength for the UN system. The activities of the agencies or organs are further supported by their subsidiary agencies. The UN system, even though is largely a platform for the intergovernmental organization, the non-governmental organizations are also given a significant platform through the UN Charter. The UN agencies are: number 1, United Nations General Assembly, UNGA. The UNGA is the main deliberative, policy-making and representative organ of the UN. It provides a unique platform for multilateral discussions of the full spectrum of international issues covered by the Charter. Presently, it has 193 members. The important activities of the UNGA are undertaken by the committees such as the main committees, which has 6 subcommittees, and other committees such as credential committees and general committees. The 6 subcommittees in the main committees of the UNGA are: the first committee is the Disarmament and International Security Committees. Second committee is Economic and Financial Committee. The third committee is Social, Humanitarian and Cultural Committee. The fourth committee is Special Political and Decolonization Committee. The fifth committee is Administrative and Budgetary Committee, and the sixth committee is the Legal Committee. UN subsidiary agencies. The subsidiary organs are established with the aim to support the activities of the UNGA. The subsidiary organs are divided into categories such as boards, commissions, committees, councils, panels, working groups, and others. After discussing the items on the agenda, seeking where possible to harmonize the various approaches of the states, the subsidiary agencies presents their recommendation, usually in the form of draft resolution and decisions, to a plenary meeting of the UNGA for its consideration. The Security Council. The Security Council has the primary responsibility for the maintenance of international peace and security. The UNGA elects 15 members divided as 5 permanent members with veto power and 10 non-permanent members for a 2-year term. Each member has 1 vote. All member states are obliged to comply with the Council decision. The Security Council takes the lead in determining the existence of a threat to the peace or act of aggression. It calls upon the parties to dispute to settle it by peaceful means and recommends method of adjustment or term of settlement. In some case, the Security Council can resort to imposing sanction or even authorize the use of force to maintain or restore international peace and security. The Security Council also recommends the appointment of Secretary General, Judge of the International Court of Justice to the UNGA. They also deal with the admission of new members to the UN. Subsidiary agencies. Under Article 29 of the UN Charter, the Security Council may establish such subsidiary agencies as it deemed necessary for the performance of its function. The subsidiary agencies are: number 1, Counter-Terrorism and Non-Proliferation Committees; number 2, Military Staff Committees; number 3, Sanction Committees; number 4, Standing Committees and Ad hoc Bodies; number 5, Peacekeeping Operations; number 6, International Tribunals; number 7, Advisory Subsidiary Body, Peace Building Commission or PBC. The third agency is Economic and Social Council, in short ECOSOC. ECOSOC is a principal organ to coordinate the economic, social and related work of the UN and the specialized agencies. The Bureau of ECOSOC includes one government from each of the 5 world regions: Latin America and the Caribbean, Africa, Asia, East Europe and West Europe, and other developed countries. Each year, a representative from a different region is chosen to head the council as its president. It has 54 members. The council holds regular meetings throughout the year in alternate years in New York and Geneva. The meeting is divided into 5 segments: high-level coordination, operational activities, humanitarian affairs and general. The high-level segment regularly attracts policymakers from the top rank of government. The segment Annual Ministerial Review (AMR) and Biannual Development Cooperation Forum has been a notable success to focusing on selected themes drawn from UN Millennium Development Goals. NGOs and ECOSOC. The consultative status NGOs has the privilege to participate, present written contributions and make statements to the Council and its subsidiary bodies. The Council is empowered to recommend consultative by UN Charter under Chapter 10, Article 71. The consultative status are divided into 1. Category 1, which has basic interest in most of the activities of the Council. Number 2, Category 2, which has a special competence in some field of activity of the ECOSOC. And number 3, roster, which has divided into 3 categories. Number 4, International Court of Justice. The court is the principal judicial organ of the UN. It was established under the UN Charter and began to work in 1946 in the Peace Palace, The Hague, Netherlands. The court is composed of 15 judges, which are elected for a term of 9 years by the UNGA and the Security Council. It is assisted by a registry, its administrative organs. Its official languages are English and French. The court role is to settle in accordance with international law legal disputes submitted to it by states and to give advisory opinion on legal questions referred to it by authorized UN organs and specialized agencies. The court has no jurisdiction to deal with application from individual, non-governmental organization, corporation or any other private entity. It cannot provide them with legal counseling or help them in their dealings with the authorities of any state whatever. Only UN member states are eligible to appear before the court in contentious cases. Number 5, Trusteeship Council. When the UN was established in 1945, 750 million people, almost a third of the world population, live in territories that were non-self-governing, dependent on colonial powers. The Council's primary responsibility is to guide UN decolonization effort, including respect for self-determination of all people through monitoring certain territories known as trust territories. Those territories is subjected to separate agreement with administering states, were formally administered under mandates from the League of Nations or were separated from countries defeated in the Second World War, or were voluntarily placed under a system by states responsible for their administration. The present status of of the Trusteeship Council. The Trusteeship Council suspended operation on 1st November 1994 with the independence of Palau, the last remaining UN trust territory, on 1st October 1994. By a resolution adopted on 25 May 1994, the Council amended its rule of procedure to drop the obligation to meet annually and agreed to meet as occasion required or by the decision of its president or at the request of a majority of its members or the UNGA or the Security Council. Number 6. The Secretariat. The Secretariat supports the diverse day-to-day work of the UN. It also provides service to other principal organs of the UN and administers the program and policies laid down by them. The Secretariat has around 43,000 staff members around the world. The head of the Secretariat is the Secretary General, who is appointed by the UNGA on the recommendation of Security Council for a 5-year renewable term. Presently, Ban Ki-moon is 8th Secretary General of the UN, succeeding Kofi Annan. Indigenous people and the UN agencies. The involvement of the UN agencies, especially the UNGA, ECOSOC, and the specialized agency ILO, can be traced back since the establishment of the UN. Their contribution should be acknowledged and appreciated. However, it should not be mistaken that these are the only agencies working for indigenous people. Rather, it reflects the contribution and support of other UN agencies. The contribution of the government and intergovernmental bodies should be acknowledged, as a member of the UNGA and ECOSOC are government representative. At present, every agencies of the UN, any specialized agencies, have a room for indigenous issues, either in the form of cell or department or division. Some of the significant agency-wise activities are discussed below. Number 1, ECOSOC. The Commission on Prevention of Discrimination and Protection of Minorities, presently Subcommission on the Promotion and Protection of Human Rights, was first constituted in the year 1947. The Subcommission on Prevention of Discrimination and Protection of Minorities launched a study on the problems of discrimination against indigenous population, also known as Martinez-Cobo study, in the year 1972, 20 June. The Working Group on Indigenous Population, WGIP, was established in the year 1982. The Indigenous Fellowship Program was launched in the year 1997. The UN Permanent Forum on Indigenous Issues was established in the year 2000. The Commission on Human Rights decides to appoint a special rapporteur on the rights of indigenous people as part of the system of thematic special procedure in the year 2001. The expert mechanism on the rights of indigenous people, or Hrm&Ip, was established in 2007 after abolishing the Working Group on Indigenous Population. Specialized Organization, ILO, International Labour Organization. In 1953, the International Labour Organization published a study, Indigenous People Living and Working Conditions for Aboriginal Population in Independent Countries. The Indigenous and Tribal Population Convention 1957, number 107, was adopted in the year 1957. It was the first attempt to codify international obligation of states in respect of indigenous and tribal populations. Convention number 169 is a legally binding international document adopted in the year 1989. It deals specifically with the rights of indigenous and tribal people. UNGA, United Nations General Assembly. The establishment of UN Voluntary Fund for Indigenous Population in the year 1985 was a significant milestone to indigenous people movement. UNGA proclaimed 1993 as the International Year of the World Indigenous People in the year 14 December 1992. UNGA proclaimed International Decade of the World Indigenous People 1995 to 2004. On 21st December 1993, UNGA proclaimed 9 August as the International Day of the World Indigenous People on 23rd December 1994. This marked the first day of the UN Working Group on Indigenous Population in the year 1982. UNGA proclaims Second International Decade of the World Indigenous People on 22nd December 2004. UNGA adopted the UN Declaration on Rights of Indigenous People (Hrm&Ip) on Thursday 13 September 2007 by a majority of 144 states in favor, 4 votes against and 11 abstention. Conclusion. The movement for promotion and protection of indigenous people rights has been strengthened not only by non-governmental organizations and indigenous people but also by the UN and its agencies. Moreover, the support of the UN member states is reflected by the adoption of the Hrm&Ip. However, the necessity of lobbying their respective governments and the regional intergovernmental bodies need to be strengthened to adopt the UN Convention on Rights of Indigenous People as a legal binding international document.